I want to say that we need to understand the history of this judicial purge. And those who can remember when His Excellency, the late President Kibaki, took over in 2002, we had what was called the judicial surgery that was led by Justice Ringera. And we all remember that during that judicial surgery, it was a justice for the valiants, that individuals who are serving in the bench during the time of Moi were deliberately targeted because they were seen as if they were undesirable characters in the judiciary. Perhaps some of the reasons why some of them were targeted is because they gave unfavorable judgments and ruling that did not augur very well with the opposition of those days. And you remember that it is the opposition that had taken over power in 2002 that initiated the judicial surgery. In my view, it was akin to justice by the valiants or justice for the valiants, or akin to what happened in Nuremberg Tribunal or the Turkey Tribunal after the Second World War. Then fast forward, and of course, the reason why the judicial surgery was done by Ringera, with the blessings of the regime that was then, was the allegation that they wanted to weed any undesirable elements in the judiciary. Of course, corruption, the 202, 203 judicial surgery. But even after the judicial surgery, we still did not get to clean our judiciary. It is still continued to be in those situations of disarray, noting that by then the judiciary did not enjoy a full constitutional independence. And fast forward, therefore, it meant that by then our judges or the judiciary would easily be influenced by the executive. And so the reason behind the judicial surgery in 2002, 2003, or rather even 2004, was to make sure that we have an independent judiciary that is responsive to the plight of the people, a judiciary that is delinked from the executive influences and excesses. And that was the reason why the purge was carried out. But again, fast forward after the 2002, we had the 2007 elections. And again, we all know what happened. That although the Constitution, the 1963 Constitution required that any person who is aggrieved by the election results would go and challenge those results in the High Court, the presidential elections, the opposition then, led by Raila Odinga and his colleagues, refused and declined to go and challenge the results in court. And of course, the reason was that there is no point of us going to court to challenge these results because there is no possibility that justice will be done. And therefore, we all know that as a result of people lacking confidence with the courts, as a result of people feeling that the court is not independent, the court is not capable of dispensing with substantive justice, we knew, or we remember, that the country took the direction of the post-election violence, that the country almost broke into civil war. It is after that incident, therefore, that Kenyans decided that we need to have a new beginning. And one of the targets was that they targeted the judiciary as one of the institutions that must claim its full independence and be completely delinked to the executive and the excesses of the executive. And therefore, we decided deliberately during the promulgation and the formulation of the 2010 Constitution to create an independent judiciary. But again, also remember that there was a fundamental question that even after creating an independent judiciary, how do we handle and how do we wind out those bad elements that remained after Ringera's judicial surgery. It is then that Kenyans decided that to completely do what the Gen Zs are calling finish Kumalo, so that we can finish this exercise completely, they decided to put transitional clauses in our constitution that required vetting of our judges. That is when Parliament therefore created the Vetting of Judges Act. Shadrau was brought in as the person sitting in the vetting board. And the vetting board also became a chopping board that was supposed to weed out bad elements in the judiciary and make sure that we have a judiciary that reflects the aspirations, the wishes, and the aspirations of Kenyans. One of them being a judiciary that is independent, a judiciary that is reliable, a judiciary that is free from external influences, and a judiciary that can guide and steer our democracy to growth. And remember, at that particular time, we had just promulgated the new constitution. So Kenyans decided that deliberately, we must vet all our judges. There were various criteria that were created under the Vetting of the Judges Act. One of them was to look at the temperaments of the judges. How does this judge conduct her affairs in court? And on that scale alone, so many judges were shown the door. There was a scale of corruption. How did you amass wealth, or rather, have you been influenced? There was also the question of the competence of the judges. How do you deliver your judgments? So there were various criteria and various tests that were put in place by Shadrach Rao's vetting board. And most of them were sent home on those counts. And therefore we thought that after the Shadrach Rao's vetting, we therefore thought that we have now attained the judiciary that we have always aspired to have. Remember, after that is when therefore the Supreme Court again was constituted for the first time in our republic, with the Chief Justice Willy Mutunga at the helm. And of course, you remember that Chief Justice Mutunga brought into place the current existing policy that is guiding the judiciary, which is a transformative and a people-responsive judiciary. We all remember the vigorousness in which the Judicial Service Commission vetted the judges of the Supreme Court. But before I speak about that, permit me to mention that the 1963 Constitution had not created an independent Judicial Service Commission. The Independent Judicial Service Commission was created by the new Constitution. And we removed the responsibility and the task of appointing judges from the executive to an independent commission created by our Constitution under Chapter 15. And therefore we thought that delinking the processes of appointing of judges from the executive to an independent organ, it would bring forth the independence and the reliability that people are seeking to have. Therefore, the 2010 Constitution introduced the Judicial Service Commission. And the Judicial Service Commission was tasked with the responsibility of hiring and firing judicial officers, be it the magistrates or the judges of the superior courts. And after that, you remember that we created the Judicial Service Commission Act, and the functions for the Judicial Service Act, Judicial Service Commission were created by the said Act. Among them is listening to complaints against judges or magistrates. You remember, therefore, the vigor in which the Judicial Service Commission participated during the constitution of the Supreme Court, bringing in people who are completely fresh from the civil society, with Dr. Willy Mutunga at the helm. You remember Nandis Baraza also coming from the civil society and the rest, and thinking that we need to have a new beginning of a constitution. And the Supreme Court then reflected the new judiciary that people wanted to have. And therefore, the Judicial Service Commission, with the task of disciplining our judges and hiring judges, had to be constituted, and various categories of individuals were targeted as individuals who would contribute to that commission. Among them is the LSK with 2 representatives, a male and a woman representative. Number 2 is a judge of judges of the High Court, currently being represented by Justice Murima. Number 3 was a judge of the Court of Appeal, representing the judges of the Court of Appeal. Number 4 was a judge of the Supreme Court, currently Justice Ibrahim Mohammed, representing the Supreme Court. And of course, with the Chief Justice being the chair of the Judicial Service Commission. The magistrates also have a representative. The Attorney General is equally a member, of course, that one coming from the executive. The Public Service Commission with 2 members representing the members of the Public Service Commission, and 2 members representing Wanjiku. And therefore, that is how the Judicial Service Commission, the JSC, was to be constituted, and how it is currently constituted, with all these players being effective. Of course, knowing that from the legal side, that is the judiciary and the LSK, their representatives to the Judicial Service Commission are competitively elected by the members. And that distinction is important because it will help you remember that the members coming from the Public Service Commission are not competitively elected. Equally well, the Attorney General representing again the state and the executive, and 2 other members. Those are or come in as through the means of appointments. So fast forward, and with the current situations that I can land and allow others to contribute and submit, it should be remembered, as you have reminded people, Redemptor, that how the whole episode began. And therefore the question to me that I would wish to address is, 1, even as we look at the merits of the complaints pending before the Judicial Service Commission, there is a fundamental question that we must ask ourselves, whether the same is brought in good faith or the same is mollified. This is because if you were to say, and you remember, you must carry the memories of how I have indicated how this JSC is constituted. If you were to say that then we want to remove and replace the entire Supreme Court, the question is, noting the role the Supreme Court plays in crystallizing and stabilizing our democracy, and remembering that there are some fundamental institutions that are key in determining how this country will be governed are not in existence, namely the IEBC. Is it right for us at this particular time to condemn the Supreme Court and condemn it? What will be the consequence in the event we are unable to reconstitute the IEBC? What will be the fate of our democracy and our country if the Supreme Court is sent home in the absence of key players? And number 2, even if we were to have all those institutions in place, noting that the works and the functions of the IEBC through an elections are challengeable before the Supreme Court. do not end at the pronouncement of the votes. What will be the consequence of us sending home the Supreme Court 1 year or 2 years to the elections? Number 3, note the Chief Justice and the representative of the Supreme Court, Justice Ibrahim Mohammed, will not sit in that commission. We shall therefore remain with 9 commissioners. These 9 commissioners, we must remember that 5 of them comes through the means of appointment by the executive. That is 2 from the Public Service Commission, 2 representing the public, the Attorney General. And equally well, even the representatives of the LSK. You remember during the LSK elections for the commission, people were a bit jittery that the member that was just about to be elected is more inclined to the executive than to the members. It will therefore tell you that we shall have 5 commissioners against 4 if the 4 of them would resist any persuasion from the executive. So the risk that we must be running is therefore that we might reconstitute a user-friendly Supreme Court, and of course user-friendly with the idea of the 2027 elections in mind. Number 3 or number 5, it is not obvious the recommendation, obvious that the recommendation by the JSC and listen to those complaints will culminate into the constitution of a tribunal to hear these cases or these complaints against these judges. There are 7 judges. It means the tribunal might have the entire of this year and next year adjudicating over these complaints. What therefore follows is, and the risk we will be running is that 2027 will come and find cases may still be pending before the tribunal. And remember, the works of the tribunal and the functions of the tribunal
Okay, your network is glitching. Okay, Ndegwa.
Sorry, there are guys. No, and I'm just about to land. Noting that the functions of the tribunal are still challengeable before the High Court. It may therefore mean that there may be legal challenges that will be posed if they were to be courted. The tribunal may never sit, and 2027 may find us still in the situation whereby we are still saying the matters or the complaints are still pending before the tribunal. That is to say, if 2027 comes, elections are conducted, there may be no institution that can sit and adjudicate over the disputes arising from the presidential elections. Remember 2007, we went to the streets and post-election violence occurred as a result of the non-existence of a judicial organ that was competent enough to adjudicate over this matter. The removal or the inability of the Supreme Court to act will still lead us to where we were in 2007. A court that cannot function. As I land, I think the country is walking on a very thin rope. And we must be very careful, sure that we do not towards that direction. Allow me to land there and hand over the mic.